You
Yeah.
can
It's surprising because, we've been live streaming on YouTube for quite a while, but that's fine. So, we'll be recording the session and I'll broadcast this now.
Vignesh was telling me there's an option to Facebook
Facebook.
Live this. I'm not.
But we can make it live only on one platform, either YouTube or Facebook. So we
Okay.
prefer YouTube because it's saved well, it's more accessible, and you can always share it on Facebook as well, right? The YouTube link.
Right.
So cool, everyone. Then I'm going live with the webinar. Okay,
All right.
Aman, Vignesh.
Yes, sir.
Yeah.
Yeah. Thank you.
Good afternoon, everyone. Thank you so much for turning up for this webinar. Firstly, all of us hope everyone's safe and healthy in these difficult times. And it's great that all of you have taken time out to attend this webinar. Uh, this is a joint webinar hosted by the ADR board and the Moot Court Society of NLS Bangalore. And it deals with the problems that international arbitration currently faces in the wake of COVID-19. We'd also like to thank Loctopus for providing us this platform wherein we could reach out to so many people and have this. And with that, this is the first session. We have two sessions. The second session will start at 5:30 p.m. The first session that it deals with innovations in ODR, which is online dispute resolution, in the wake of this pandemic. Uh, we'd like to thank all the speakers and the panelists who've taken out the valuable time and joined us for this webinar. We have speakers from across the world, and we're obliged that they actually found time to come and address all of us here. I'll start by introducing the speakers. Uh, First, we have Ms. Shwetha Bidhuri. She is the South Asia head of the Singapore International Arbitration Center. She has enrolled as an advocate in 2017 and she holds a master's degree. Before joining SIAC, she worked in the dispute resolution practice of a leading New Delhi firm for nearly a decade on commercial litigation cases, as well as investment arbitration. She has worked on many leading cases which have contributed to the development of law affecting global companies as well. We also have with us Miss Angeline Welsh, who is a barrister at the Essex Court. She has been a commercial litigator with over 15 years of experience, and she has specific expertise in international arbitration. She has litigated a broad range of commercial disputes, including those in the energy, telecoms, financial, construction, manufacturing, and shipping sectors before English courts, and other tribunals like the LCIA, the Hong Kong Court, the ICC, and many others. She was also the counsel and solicitor advocate and with a major international law firm previously, and she has a unique insight of the pressures and demands in the instructing solicitors, as well as significant experience of leading teams and building strategy. We're fortunate to have with us Mr. Nihal Joseph as well, who is an associate in the international arbitration team at Herbert Smith Freewills. He specializes in international commercial arbitration with experience in a range of sectors, including energy, mining, financial services, and technology. He has also represented clients based in various jurisdictions under the rules of major arbitrational institutes like the ICC, the LCIA, the HKIAC, and the SIAC. Lastly, we have with us as a panelist Mr. Thayananthan Baskaran, who is a partner at Baskaran, Kuala Lumpur, and an associate member of the Crown Office Chambers in London. He was appointed as an adjudicator in the 15th statutory adjudication registered in Malaysia, and he now regularly sits as an adjudicator as well. He is on the panel of several international arbitration centers, and he has been appointed as an arbitrator in various commercial disputes as well. He has written a book on arbitration in Malaysia, a commentary on the Malaysian Arbitration Act, which has been published by Arbitration International as well. He was also the chair of the Chartered Institute of Arbitrators Malaysia branch and the president of the Society of Construction Law Malaysia. Lastly, we have our moderator, Ms. Shreya Aren, with us, who is an associate in the international arbitration team of Debevoise and Plimpton. She is based in the London office and has graduated from the National Law School of India University, Bangalore in 2012. She was admitted as an advocate in 2012 and is qualified as a solicitor in Wales and England in 2014. Her practice focuses on international commercial and investment treaty arbitration, and she joined Debevoise in 2019 recently, prior to which she was an associate in the international arbitration team of Allen and Overy. We're extremely proud to have this stellar lineup of panelists here, and we hope that they can lead the discussion in a way that helps all of us. With that, I'd like to hand over the floor to Ms. Aren, but before that, simply to address all the participants, with respect to any questions that you may have, please type them out in the Q&A box, and as and when panelists can, they will address those questions, they will incorporate within their discussion, and in case we miss out questions, those can be answered later as well. Unfortunately, we won't be able to answer all the questions posed to us, but we hope to cover as many as possible. With that, I'd now like to hand over to Ms. Shreya.
Thank you, Aman. Good afternoon, everyone, and welcome to the first session of the webinar on contemporary issues in international arbitration. It's my pleasure to be moderating this first panel where we will be talking about arbitration during COVID-19. It's no exaggeration to say that we're living through unprecedented and extraordinary times, which are affecting pretty much every sphere of our lives, and disputes are not an exception. The measures taken in light of COVID-19 pandemic have presented a unique set of hurdles for arbitration and dispute resolution processes. So today, with a very esteemed panel, we will be discussing some of the ways in which the pandemic has affected the world of international arbitration. We're going to try and keep the conversation interactive. So I'll be posing some questions for the panelists. If the attendees have questions, as Aman mentioned, please put them in the Q&A box and we will try to discuss those during the course of the panel. So without further ado, my first question, which perhaps we can start with Thaya, how has the fora that you normally arbitrate or litigate in been affected by the pandemic?
Yeah, thank you very much, Shreya. Very happy to be speaking to you all this afternoon. To answer Shreya's question, the result of the COVID-19 pandemic has been lockdowns instituted in most jurisdictions. Malaysia has just come out of a lockdown on Monday this week, and I think several countries are still under lockdown, including Singapore, England, and India. The lockdown, I think in most jurisdictions, it was imposed in stages. So, it was like for 2 weeks and then extended for another 2 weeks and so on. So because of the staged extension of the movement control restrictions, at the initial stages, parties were quite happy to simply adjourn matters. But then as parties saw that it was just going to go on for a protracted period of time, they started looking at options, at how to manage timelines and get hearings done in the light of these social distancing regulations. So here in Malaysia, we have the Asian International Arbitration Center, which has continued to operate remotely throughout the lockdown in Malaysia. Cases have continued to be registered at the arbitration center. Cases have been actively case managed, and they've also offered virtual hearing facilities. We're also happy to have seen that the courts have risen up to the challenge and have actually provided virtual hearing facilities as well. So on the 29th of April, actually for the first time in Malaysia, we've had proceedings in the Court of Appeal being live streamed. And that was actually quite interesting to various members of the public to whom it was open, because they never actually seen proceedings in court before. And everyone had imagined it as what you'd see on TV. And they were quite amused by what you actually see going on in court. Interestingly, it was opened up for comments from the public as well, the live streaming. So you got various very interesting comments coming in during these proceedings in the Court of Appeal in Malaysia. So, to that extent, matters did go on even during the lockdown, but certainly there was some initial delay, which is now being managed. Here, the lockdown has been lifted, so things are pretty much slowly returning to some level of normality.
Thanks, Thaya. Shwetha, can we hear from you about what SIAC's experience has been during this time?
Firstly, thank you, NLS, for inviting me to this webinar. I think it's a very value-creating Sunday, which would have otherwise been sort of spent sleeping or watching a movie. But it's good to hear from Thaya on the fact that the lockdown has been lifted in his country, which is, gives some hope to us, who've been especially stuck here and haven't gone out for days now. From SIAC's point of view, so of course, when we started to take different measures, it first started from working from home, and we had reduced number of people who were attending in the office. But in terms of filing, we've been seeing steady number of filings. So one major change that had happened was, instead of physical filing, everything is now electronic. So when the parties wanted to commence their arbitration, it was all now sent via email. So, I mean, for us standpoint, nothing has really change in terms of workload. It is business as usual. We remain fully operations. We're seeing filings. Initially, the first reaction, especially the big hearings which were lined up, was to adjourn them. But with that also, we didn't know how long will that get adjourned, because this has been longer than all of us thought it would be. So in a lot of those cases, we are seeing where parties are now considering to hold virtual hearings. And of course, there have been some cases where they've gone ahead with virtual hearings. There have been some emergency arbitrations that have come up and taken place on a virtual hearing. I think more so because the courts now are only hearing urgent matters. So if you want an urgent relief, instead of, for example, in India going for a Section 9, you're better off to come to an institution, get an emergency arbitrator and get the relief that you urgently need. So, but I think as, in terms of whether or not there have been COVID-related cases, I think that there seem to be a lot on the horizon, because it will start to unfold now, wherever the disputes may be. But we've been seeing a record number of cases for this year early on. Yeah.
Thanks, Shwetha. Angeline, could I ask you to address what's going on in the English courts and in the arbitration world?
Yes, thanks, Aren. Thank you very much for the invitation to speak to you all this afternoon. Well, I suppose there's two relevant procedures to comment upon. One is how the English court's coping, and then secondly, what are we seeing in international arbitration? Particularly how the English courts are coping, I think will become relevant to questions of enforcement, which we might talk about later, and potential challenges towards, because the English courts in particular have been incredibly robust. We went into lockdown in the UK, I think around mid-March, but already by the time we went into lockdown, protocol had been issued by the English courts, which made it clear that proceedings for the majority of civil proceedings would proceed by way of remote hearing. And there have now been various different applications to adjourn hearings. And I think one of the sort of most high profile first ones was on the 19th of March in the commercial court, where a party sought to adjourn the substantive hearing due to logistical issues, primarily arising out of the COVID-19 pandemic. And the English court refused to do that, bar a short adjournment, just to allow everybody to prepare for the hearing. So the English courts are proceeding very robustly. We have even a new section of our white book, which is our civil procedure rules, which governs how one deals with remote hearings and English court procedure in light of the pandemic. And if you want to know more about that, then you can see a piece which I've written on the Essex Court website together with my colleagues Hugh Mercer and Naomi Hart. So that English courts are proceeding apace with very limited difference, other than everyone is sitting individually in their homes addressing a screen rather than the judge in person. As far as arbitration is concerned, I think the international response has been fairly similar, which is that it's not unusual when the pandemic hit for arbitration proceedings to be adjourned. And certainly sitting as arbitrator myself, I had one case which was fixed for the beginning of April, which was adjourned immediately. And the reason for that, I think, sort of arose out of the fact that everyone had been planning to be in one particular place and to conduct hearings in a physical basis. And there needs to be a shift in terms of mindset and organisation to deal with a remote hearing. But now we are starting to see arbitration proceedings proceed on a remote basis. But we might talk a little later about the ways in which that can affect the process and why parties are not necessarily always happy with that.
Thanks, Angeline. Nihal, how has your work and practice been affected by COVID-19?
Thanks, Shreya, and thanks to the NLS team for organizing this discussion. It's a real pleasure to be here. As Aman mentioned, I focus mainly on commercial arbitration. So the forum I'm most familiar with is an arbitral tribunal seated in London, Singapore, Mumbai, or anywhere else really. And I agree with Angeline that in this forum, we are having to change the way we work in quite dramatic ways. But at the same time, we're not starting from a standing start. We have been on the learning curve of doing remote hearings for quite a while. We're used to parties and tribunals being in different locations. And so I think people are carrying on as best as they can as normal. I think sort of in contrast to what the English courts are doing, the position is slightly harder in India, because I know that some high courts are only hearing urgent matters, as Shwetha mentioned. So, normal civil trials and applications aren't progressing as quickly as parties would have liked.
Great, thank you. So moving on to then the mechanics of arbitration a little bit. If I am someone who has a contract with an arbitration agreement and I find myself with a dispute right now, or if I'm a lawyer advising such a person, what are the considerations that I should have in mind while deciding whether to commence an arbitration, given the current circumstances? Angeline, could we start with you on this question, please?
Yeah, I mean, in some ways, I would have thought that the primary considerations are going to be business considerations, because, and I think this is something which Nihal has just mentioned, in terms of procedure, very little really has changed in terms of commencing an arbitration. I mean, been very possible to commence an arbitration remotely. Arbitration teams are used to working remotely. So there's obviously some, it may be that you would want to see your lawyers face to face, you might want to take evidence face to face before starting an arbitration, but I think we're all becoming quite used to this new world where our meetings are conducted in this format rather than on a face-to-face basis. So what are going to be the primary considerations? Well, I would think that unless you're up against a legal time limit by which you've got to commence the arbitration, the factors which are going to operate more on the mind are considerations of, what is the business's cash flow? Is this a sensible way in which to type cash? There may be a greater pressure to seek to mediate disputes rather than get tied into litigation when the business world feels pretty uncertain at times. But in terms of procedure, I'm not really convinced that very much has changed in that regard.
Thanks, Angeline. And Taya, just posing the same question to you, what should parties be considering while deciding whether to commence an arbitration during this time, particularly in the context of courts, as we've just heard, some courts like the Indian courts not functioning regularly as they were used to?
Yeah, thanks, Shreya. I tend to agree with Angeline. I think the primary consideration will really be a commercial decision driven by financial pressure as to whether or not to commence arbitral proceedings at this time. Insofar as the COVID-19 pandemic is concerned, I think the primary consideration for parties will be, to what extent, if at all, is the pandemic going to delay the proceedings, and what is the effect that it's going to have on the proceedings. So, I mean, that also really depends in the context of international arbitration on the particular jurisdictions you're dealing with. As you mentioned, the position is different in India, it's different in England, and it's different in Malaysia as well. In some countries, like in Malaysia, we're not operating under a complete lockdown anymore. So a lot of those considerations are no longer there. But if there are severe social distancing regulations which are still in place, then various things should be considered. I suppose you would go through a sort of checklist of what's going to happen in the arbitration and see what stages are likely to be affected. So if you look at stage 1, getting it registered and commenced, I think almost all arbitration institutions will now let you register and commence it electronically. As Shwetha mentioned earlier, the SIAC allows for that, the AIAC here allows for that. The ICC in their guidance notes has encouraged that be done as well. So that's not a problem. Then if you go on, to the service of documents, again, that's allowed electronically under most institutional rules. A lot of countries by legislation as well allow electronic service. So if you look at Hong Kong, the Act allows for electronic service. Here in Malaysia, the Act also allows for electronic service of documents. So that takes away the problem of serving, any documents in the arbitral proceedings. The next is, the pleadings or the written statements stage of the arbitration, what's going to happen there. If we look at that, presumably the claimant is going to be ready, because otherwise they wouldn't be starting the arbitration. So they would have the documents, the particulars, and have, probably instructed their solicitors already. Insofar as the defendant, the respondents are concerned, I guess the claimant would need to bear in mind that there could very likely be some delay. The defendant may say that they simply don't have access to documents because of the lockdown. When Malaysia was under lockdown, for example, I didn't have access to my office because it was a complete lockdown. So for over 50 days, I didn't have access to my office. Of course, in present times, most documents are available in electronic form. But that said, some things, some key documents may only be in hard copy, and those could be fairly voluminous documents. My primary area of practice is construction, so you have these voluminous contract documents which run into thousands of pages, which sometimes are not entirely converted into soft copy. So that can cause delays. And finally, the event that's most likely to delay the proceedings will be the hearing itself. Two aspects to that, one in terms of legal submissions and the other in terms of evidence. In terms of legal submissions, that's, it's usually dispensed with in most international arbitration proceedings I've been involved in. So you'll just email that across. In terms of witness testimony, I guess, one thing is you may need to seriously consider virtual hearing proceedings. I'm a big fan of them. I think they work fairly effectively. You can also look at the possibility of documents-only proceedings. And finally, to address your question on courts, again, it depends on the jurisdiction you're operating in. Some courts have been up and running, some are not. Looking at an application to enforce itself, I mean, I think in most jurisdictions which are going to have some kind of virtual hearing scenario, it seems like a type of application that's particularly suited to that. It's something that's going to be decided based on documents and affidavit evidence, so it can easily be disposed of online. So I think, insofar as COVID is concerned, the main issue will be whether it's likely to delay the proceedings and how that delay can be managed. Thanks.
Thanks, Thaya. And just to answer one of the questions that we've had in the Q&A box about whether we're seeing a complete move towards e-filing and online proceedings for arbitration once the pandemic ends. If yes, then how important will be that move? And I think you touched upon this, Thaya. I think most of us who do arbitration know that that kind of process is already complete in a sense. Most of our filings happen online and using email. So I think even before the pandemic, we were definitely seeing most of the submissions being filed online. And I think now we have guidelines from a lot of institutions which basically say that filing should be done electronically. So I think that kind of move we've seen that that's already happened. The next question I had was for you, Nihal. Given the much touted procedural flexibility that international arbitration has, are there ways in which arbitration is currently more advantageous than litigation? And just to wrap in a question that we have in the Q&A box as well, which says, how can ADR be used to reduce the pendency of cases in light of courts being closed during this lockdown? So how is it that arbitration can help during this time?
Thanks, Shreya. And look, I think the answer is yes. There is more flexibility in arbitration than there usually is in court procedures. Well, let me start off first by saying that commercial courts across the world are and have been for many years very quick to adapt to change. And in some ways, they are leading the way on finding more efficient and innovative ways of resolving disputes. Many of them already have experience with remote hearings, with e-discovery, with electronic bundles and things like that. So when I say that arbitration is more flexible, I don't mean that the courts are being inflexible or slow to adapt to this crisis. But I think that the broader procedural setup in arbitration is more conducive to a bespoke approach to each dispute. And the reason for that is that the rules of arbitral institutions don't need really to be amended or updated to deal with this crisis. Many procedural issues are decided between the parties, and tribunals have wide range of discretion to deal with case management issues. And there's a bigger question, and I'm sure we'll come on to it, about whether and how much parties are using this flexibility, and we'll talk about due process concerns. But I think particularly where there are jurisdictions where courts have suspended normal civil trials, arbitration is offering a solution and a sort of way to cut through that problem. Usually, this is a moot question because your contract will tell you whether you need to go to a court or you need to go to an arbitral tribunal. But there has been some interest lately in moving existing civil trials from national courts into arbitration, particularly where there is a suspension of normal trials. And there's even a protocol that's being developed by a team in 20 Essex to do this in an orderly way. So yes, I do think that there is some flexibility there.
Thank you. And just to, there's one of the questions that's come up in the Q&A box about what are the safeguards required for filing. And if that's something that you're interested in, then you should tune into the second session, which is about cybersecurity. So I'm just mentioning that for people who are interested in that. Moving on to the next question, and this one's for you, Shwetha. It's about what kind of solutions and innovations can council and tribunal do to ensure that arbitrations run smoothly during these times? And from your perspective, from an arbitral institution, what kind of solutions have you seen being developed and undertaken by tribunals?
So the good news is, as Nihal said, that the inherent ability of arbitration to be flexible, to be able to sort of mold itself in terms of the changing circumstances is what is going to come at hand. I think we have underutilized what arbitration is capable of. Despite a lot of things that we are now experimenting and doing, all of this could have been done much earlier also. But now the situation compels us to explore, not to let the things be stopped or hindered for a very long time. So, I mean, from the perspective of what the arbitration institution and the arbitrators and of course the parties, what they need to do, I think above everything else is a sense of cooperation, and I think the only big concern in moving fully virtually is really the due process paranoia. And which once the parties cooperate, you really get past that much easier. From the institutional point, there are of course various rules that allow you to have documents only arbitration. You have expedited arbitration. So if it's not a really complex case where you don't really need witnesses to be cross-examined, and if it can be dealt on an expedited procedure or on a documents only arbitration basis, then the parties must consider it, and the arbitrators must also encourage the parties to try and take that route. Of course, another thing that is important, I think more from the sense of responsibility as counsel, not to use this as a delay tactic, which has also been as a concern for a lot of people, that one side would just say that because we're not able to have access to documents, etc., and then they want to adjourn, or they're not comfortable with the virtual hearing because they feel witnesses will be better cross-examined in person. So I think, not to bring up issues if you can deal with them otherwise. Like I said in the beginning, to really cooperate, to proceed with the hearings if you really can, unless there is something, really huge for you to manage, which Thaya also mentioned is really document access. And I think there've been a lot of webinars where everyone's been discussing about, what can be done in terms of virtual hearings to deal with cross-examination of witnesses. So if we are open to it, there is a lot that can be explored. And I'm sure even with the concerns that one has, all of that can be addressed. And of course, technology is developing so fast. We instead of physical conferences, which is really the norm that we were seeing, we are so comfortably adapting to webinars. It's accessible to more people. We don't have to travel distances. So a lot of things are actually at an advantage, rather than looking at this big block that, we're not able to meet and do things. So I think the approach needs to be a little more open-minded. In fact, I had a query from someone who was thinking about initiating a dispute, and he said that for me, I think it's a good opportunity because now I can really save on costs, which would otherwise be a norm for me to travel to another jurisdiction. Now, because of these situations, for me, there's going to be significant cost savings. So I think rather than looking it as an obstacle, it is an opportunity to really cut down on costs that is not otherwise necessary. I think for companies to really consider choosing more arbitration, as the means for resolving their dispute than otherwise, because I think in all of this, arbitrations are still running as smoothly as they can.
Thanks, Shwetha. And I think there's a question there as well about emergency arbitration. And I think you raised that before as well, that there are situations in which we've had parties actually approach for emergency arbitration as opposed to getting urgent relief from the courts. So I think that's, again, something that can be used quite effectively by parties because arbitrations and arbitrators are used to working remotely in these kind of situations. Is there anything else anyone would like to add before we move on to the next question? Okay.
Shreya, I'm just going to say something just about about e-filing, which we'd already talked about. And I think you rightly made the point that actually majority of arbitration, certainly ones I deal with this way, have some form of e-filing, whether that's filing the documents with the institution or once the arbitration is up and running, then documents are regularly exchanged either by email or by a document sharing platform. And the interesting point that I want to make is, I think, and perhaps we'll come back to talk to, or when we talk about hearings, is that a useful way to think about what we're doing now is not really that necessarily things are changing, but it's just that they are operating through a different medium. So, or the change is being expedited. So when it comes to e-filing, for example, one of the issues which I'm sure they'll talk about in the next session, but which is becoming a real concern, is cybersecurity. And we are, there are some examples of arbitral institutions, but there's also no reason why this cannot be privately done, of using a documents platform so that all parties to the arbitration, the tribunal, have access to the documents, rather than thinking about it in terms of sharing, you know, paper hearing bundles. This is something that's already happened already, and I think what the effect of this will be is just to expedite that, so that that becomes the norm, rather than perhaps the unusual for, you know, very expensive cases, or you've got big law firms involved. I think that will become pretty standard. And I think likewise with hearings, one of the interesting things I think about the way the commercial court has looked at this is that they don't, I think, look at a virtual hearing as anything other than a hearing. It's not different. It's a hearing. All the same things can be done. It's just that it is done through the medium of a Zoom conference call or Skype for Business, which is what the English courts use. And I think that's a helpful starting point when you start to think about it, because when we start to look at some of the due process concerns, the question really is, well, what are you getting which is different to what you would get from a physical meeting?
Yeah, and I think that's a very good point. And one of the things that struck with me is that the decisions that tribunals are being asked to make right now, sure, they are slightly different given the circumstances, but the considerations are the same that they would, put together, consider while making any other decision on any other procedural application. So you're still balancing due process versus expediency. You're still looking at the same kind of tensions that arbitrators have always looked at. So I think you're completely right that it's just the medium which has changed, but the larger matrix is still the same. So picking up on one of the points that Shwetha raised, and this one's for you, Thaya, one of the suggestions that has proven both popular and controversial is to do with documents-only arbitration, which basically means that tribunals decide disputes based on written submissions without actually hearing any oral submissions from the parties. And so the question there is, how does that impact the right of parties to fully present their case, and what are the due process considerations associated with that?
Yeah, thank you, Shreya. I'm personally a big fan of documents-only proceedings, and I think in the vast majority of cases, it's unlikely to impact the rights of parties to present their case. Of course, there will be some cases where there is a significant dispute on the facts, which requires oral testimony. But in very large number of cases, most disputes just get decided based on the documents. So I think that it is effective, and it's unlikely to have a big impact on the rights of parties. It's not something new, as Shwetha mentioned earlier, especially in context of expedited proceedings. It's been there for a number of years in arbitration. We see it in the SIAC rules, the AIAC fast track rules, and the HPIAC and ICC expedited rules as well. They're generally intended for lower value disputes, roughly USD 3 million. But there's no reason why parties can't use it for higher value disputes as well, especially where there's no significant dispute on the facts that requires oral testimony. Here in Malaysia and in other jurisdictions, particularly in the field of construction, where there has been statutory adjudication of construction disputes, those disputes are resolved almost all the time based solely on documents, without the parties even actually meeting at any stage. So there's been a favorable response to that. Although the decision is temporarily final, they have not really been challenged in very many instances, showing that parties are quite comfortable with them. As a result, here we have seen that there has been an increased use of expedited rules even for larger disputes, which are documents only. The parties seem to have gone further than simply being comfortable with documents only proceedings, to actually being quite happy with them. Many parties are actually surprised, when you first tell them that you can have a large dispute resolved without a hearing and without, all their project team and managers having to come and, spend time in the arbitration. And they actually see that being avoided as a big advantage. And, that is actually an effective way of resolving a dispute. Which also brings us back, perhaps to the early days of arbitration, where it was meant to just be, a quick way of resolving a commercial dispute. My own view is that the strong case can be made that perhaps the default position is that proceedings be documents only, and that if you really need an oral hearing, you need to give grounds for why that oral hearing is needed. And if that is allowed, then perhaps it can be confined to certain specific issues. So I'm a big fan of documents-only proceedings myself, speaking particularly in relation to construction disputes. I find them quite effective. And I think it is something that will come out of this pandemic. Thank you.
Thanks, Shreya. And even from the perspective of costs, I think it's one easy way for parties to reduce costs. I think just not have a big hearing with a lot of parties attending, like you mentioned. So I think it's definitely something that parties should be considering even outside of the circumstances of the pandemic. And since we're talking about procedural restrictions and arbitrations, Nihal, given the current circumstances and owing to restrictions on accessing of documents, like we were talking about, or witnesses, are arbitrations being procedurally compromised? And if so, how do you balance the considerations of procedural integrity along with delay and expediency?
Thanks, Shwetha. And that's, I think, the real challenge that's sort of front and center before tribunals, even pre-crisis, but sort of magnified by the crisis. And the reason that is an issue is because we start to think about enforcement at the very outset when we're drafting an arbitration agreement and at every stage of the arbitral process. Because there's nothing worse than going through an arbitration and finding out that the award isn't worth the piece of paper it's written on, because the court won't enforce it. And there are jurisdictions that take fairly unorthodox views on enforcement, and most of those who are listening in will be familiar with debates around public policy and what a fertile ground it has become for challenges. And that's led to what Shwetha and Thaya referred to as due process paranoia, which is a sort of negative phrase, but associated with the concern that procedural decisions taken by tribunals will lead to unenforceable awards. And that means that even if a tribunal takes a tough but fundamentally fair decision on procedural issues, it might open the door to a challenge when you're trying to enforce the award. And that sort of leads to tribunals being more conservative because understandably they want to issue an enforceable award. But unfortunately, it has led to delay and costs, particularly now in this crisis when people are talking about extensions, or people are wondering whether it's appropriate to have a hearing where cross-examination is done by video link. So that is, a fundamental challenge. I would say that before the decision goes, or we look at what the tribunal is doing, you should start to think about what, as a claimant or a defendant with a counterclaim, would want to do. Because at the end of the day, if if you do a sort of cost-benefit analysis and you say, well, I'd rather not push too hard on this issue, I'd rather not resist an application that another side is making, because that reduces the risk of an enforcement challenge later down the road, then in some cases you might say, well, I'm okay with that small delay, or I'm okay with making that procedural change. But where parties can't agree, or where the decision has to be made by the tribunal, then there really are some quite unprecedented and untested issues. But I'd go back to what Angeline mentioned about what really is changing with a virtual hearing. You really have to identify the issue that the parties are facing. It's not just hearing having a hearing by video conference isn't by itself a due process issue, but it's what the consequences of that are. And it's fairly difficult to identify them in most cases. In the majority of cases, I suspect you would be able to run an arbitration without being unduly unfair on one of the parties.
Thanks, Nihal. And I think just coming to that, and that's a question that's actually come up quite a lot in our Q&A box as well, which is to do with virtual hearings. And Angeline, I think you were mentioning just before we started the panel, that you've had experience of a couple of virtual hearings, and you're sitting as arbitrator as well in one of the cases where that's an issue. So it'd be interesting to know, I mean, given that one of the consequences of the COVID-19 pandemic has been complete restriction on mobility and travel, one of the consequences has been virtual hearings. So how does one go ahead with that, especially in situations where one party wants it and the other party doesn't?
Well, I mean, the remote hearing is basically the biggest impact on the arbitration procedure, I think. Everything else can be got around in one way or the other. And so obviously that's the issue which has been primarily the focus of concern. So before I talk about my practical experience, I think it's worth stepping back and really asking the question, what is really the difference between a remote hearing and a physical hearing? And I say that in part because we had a previous discussion about whether you should have a documents only process or you should have a hearing at all. And there are some institutional rules, the LCA rules, for example, which say that parties always have a right to a hearing. Well, a hearing, I think, could mean a physical hearing or it could mean a remote hearing. So it may well be, in a perverse way, that the fact that we have this technology and we all become used to it means that we have more face-to-face hearings than we would have done previously. So, for example, the first case management conference is often a telephone conference. I think the default position may be that we're now doing this by Zoom, or we're doing it by business by Skype. I think people will start to get really comfortable with not necessarily speaking by telephone, but having these more sort of face-to-face interactions. So I think that'd be a change. And I think whether you have a documents only or you have a hearing, all the same considerations which would have previously existed, regardless of the situation that we're currently in with the pandemic, are exactly the same. I don't really think that it changes very much. So really the critical question is, what is the difference between physical hearing and a remote hearing? And it seems the issues which I've seen raised are, first, that the tribunal is somehow inhibited by being able to assess primarily the witness evidence rather than the oral submissions which are made by parties. And that is a sort of, in some senses, a slightly intangible concern, because it's about human interaction cues. Are you able to assess whether you think somebody is credible or not from the other end of a computer screen rather than seeing them in person? And I think one of the issues that's going to crop up in that discussion is ultimately just how important is witness evidence, and how much confidence should we place in judges or tribunals to really assess the credibility of a witness by what they hear in cross-examination. And this is to some extent a bit of an old debate, because Toby Landau gave a lecture, his Clayton Utz lecture in 2009, where he, I think one of the first people to bring into the discussion international arbitration, the fallibility of memory of witnesses, and so are we overplaying the role of arbitrators and judges to really assess that? But since then, in the English courts at least, there's now some well-known dicta which says that actually what judges should really be doing is looking at documents and considering what's probable on the evidence and using cross-examination as a way of testing that. So when you start to look at it through that a due process concern raised through that prism, you start to think, well, actually, if one were to say that they place a lot of emphasis on whether or not a judge or an arbitrator can assess the credibility of a witness, well, there's a question mark as to what extent they can do that anyway, is what some of the learning says. But then really, are you able to do that very differently because we're speaking like this as opposed to seeing people in person? And I think part of it comes down to, I think, the reality is if you're an advocate in a court process or a tribunal, it's much more comfortable to do that face to face. I think there is something a little bit lost in terms of human interaction, but is it possible? Well, I think it absolutely is possible. And I've appeared as counsel where someone is, a witness is being asked questions, and you know, there's the ability for an advocate to build up steam, to do cross-examination. It's sort of, there is some, it's a bit like walking through treacle, I say, but it's perfectly possible to get to the other side. And arbitrators can hear what the witnesses have to say perfectly, provided all the internet links are maintained and so forth. So I think this due process paranoia, it could be more paranoia than real. But I think, again, you know, it's one of those issues which, so far as international arbitration is concerned, you always have one mind to where the award is being challenged or where it's being enforced. And so the law at the seat or the law at the place of enforcement is going to have to play a role in this. I think the extent to which evidence, witness evidence plays a role in the overall dispute will also be a relevant issue in that respect. And that's why I think, you know, so far as the English court's proceeding in a fairly robust basis, I think tells you quite a lot about the approach that English law will take to these issues which might be raised on challenges. I don't, you know, I think the English courts will take an equally robust position in terms of challenges and enforcement on that particular point. Just in terms of practically, very quickly, practically what can you do? If one party is resisting a virtual hearing going ahead, and I would say if both parties are in agreement, there's a number of protocols which have been issued. The Hogan-Lovells protocol recommends that the tribunal documents that agreement so that they can proceed and so forth. You're obviously not going to get that if one party resists. One of the things that, apart from the discussion that we've just had about, well, identifying how important the witness evidence is to the issues in the arbitration, looking at being a bit sceptical about the ability of the tribunal or the arbitrator to interpret that. The other thing that I think can be usefully done, particularly by a tribunal, or indeed one party can suggest it, is that to carry out a test. And I think many of us who are using this sort of technology all the time will find that regularly what happens is prior to dialing in, you have a test. So I think all parties who are sitting in different jurisdictions, witnesses sitting in jurisdictions, should be encouraged to have a test of the technology and then report back to the tribunal as to whether it works. One of the issues that I've seen raised is, well, if witnesses are sitting in part of the world where the internet connection is not particularly strong, do they need to move to somewhere else where it can be? Can that be done in a socially distant compliant way? Well, I think all of these things are logistical hurdles which should be investigated thoroughly before one assumes that a remote hearing can't go ahead. I think there's enough on that.
I just may add, Shreya. So I think a lot of people in general had this query, and they've been meaning to ask, is whether the institutional rules in general allow you to have a virtual hearing. So from what SIAC's rules, and I believe that to be the case in most of the other institutions' rule, is they inherently give tribunal the power to decide the method or way in which they want to conduct the hearing. So it is not against, I mean, it would not be easy for a party to challenge a virtual hearing to say that it doesn't follow due process, or it's not been given enough opportunity to be heard, because that sort of flexibility is already inbuilt in the rules. And, you know, of course it mentions, you know, wider powers of the tribunal, but also for particularly emergency arbitration, there is a mention of video conferencing, where you can pass an order basis a hearing on video conferencing or only on documents.
And I think just to add to that, that's a very important point, because, you know, it has been to date fairly common for at least one witness or perhaps an advocate to address the tribunal through video conferencing. What is unusual about the present circumstances is that every participant in the arbitration is sitting separately in a different location, and they're participating in that way. But the principle of using a video con to take evidence is not an unusual one at all.
And I think that touches upon a really important point, because most of the cases that we do tend to be commercial cases. And you could argue potentially that there are cases such as maybe family law cases where you do need to see and evaluate the evidence in person because that involves some kind of emotional aspect of it. But given that most of the cases that tend to come to arbitration are commercial in nature, not to say that doesn't mean emotions aren't running high, sometimes they are, but it's easier to deal with those kind of legal issues and factual issues over video conference. Thaya, did you have something to say?
Yeah, just a very short point. I think it's an interesting thing which has come up, which is about the assessment of a witness's demeanor, whether it is more effectively done in person or virtually. So there is also an argument that's being made now that it's actually easier to assess someone's demeanor on a screen, because when you have someone's face, screened out in a sort of window in a way, like you can see me now, it's in a way easier to assess their demeanor because they're sort of frozen within those four corners, and you can actually quite effectively assess their demeanor. With someone being nervous, someone being slightly untruthful. I find it actually quite an effective way of assessing someone's demeanor. So I just thought that's interesting as well, that you don't necessarily lose by a virtual process. You may in fact gain because the person is sort of frozen before you in a screen.
Yeah, thank you. I mean,
can I just add that I have heard some advocates say that actually, in a way, you're almost closer to the witness because you're an arm's length away from your laptop, and that's where the witness is. Whereas in a real hearing, you aren't that close to a witness. You can't pick up cues, facial expressions that easily. And another thing is, and if everyone consents to have the hearing recorded and the cross-examination recorded, it could be quite an effective piece of advocacy to play back a response that a witness has to a question, or to look at it, 3-4 months down the line when the tribunal is looking at an award and trying to recollect, how the witness answered a question. So there might be some opportunities here.
That is a really interesting point, actually, because I can say, speaking for myself as arbitrator, it would be interesting to see, to rather than go back to the transcript, but to actually see what people look like. But Shwetha, I'd be interested to know if tribunals are recording their hearings when they're taking place by Zoom or whatever, because I'm not aware. The hearing where I've taken part as advocate in particular, there was a transcript which was taken. So there was a stenographer on the line taking his transcript, but I don't think the recording, or a video recording was made of it. But I could be wrong about that. So I'm just wondering what is the standard practice in arbitration?
I haven't seen it being done in arbitration yet because most hearings have been in person until the pandemic. But our courts, actually, all proceedings are actually audio-visually recorded, and there references have been made to the audio-visual recording when legal submissions are subsequently made. Picking up from what Nihal said, it's quite interesting actually. With the development of technology now, you can actually probably file written submissions where instead of cross-referencing to a written transcript, you could actually just, cross-reference to a link which shows you the recording of the proceedings, which, in a way, may be an even more effective way of assessing someone's demeanor or credibility.
I think that was a question for you as well, Shwetha. Have you seen any requests or any practice regarding the recording of proceedings so far?
So generally, we do not record, but if there is a request like that, then if both parties agree, then the tribunal may sort of go ahead with it. But as a practice, it's not. The live transcript pretty much records everything that has been talked about in the hearing itself.
Right, thank you. So moving on to a slightly different topic then, but I think still quite important. I mean, we've seen a lot of procedural aspects, and one of the most important is extensions and time and deadlines and how that is being affected by the current pandemic. And to that end, the English courts have actually passed a direction saying that parties can agree an extension of up to 56 days without formally notifying the court. Earlier, this was 28 days. And I was wondering, Shwetha, this is a question for you. How are arbitral institutions currently dealing with requests for time extension? And is there a mandatory relaxation period, or is it just generally being seen with a little bit more leniency?
So, I mean, as for the rules haven't changed from what it provided for in terms of the timelines for party submissions and etc. for the timeline within which the award needs to be passed. But the registrar inherently has the power to allow for such requests depending on circumstances of each case. So it has to be very carefully evaluated when a request for extension of timeline is allowed. But in general, the mindset would currently be a little more open than than otherwise. Like for example, if you're in India and there is a complete lockdown and you can't go at all and access your documents, and if a party makes a request on that basis, then it would ideally usually be granted. So, but it depends on case-to-case basis and how real and substantive the request really is. But the registrar has the power, so there's no real need to amend the rules to bring in, as per this particular situation.
And in practice, is that being, maybe I'm putting you on the spot here a little bit, and obviously I don't mean to ask you to give a general relaxation of extensions on this webinar, but just generally, are time extension requests being dealt with generally more leniently in practice as well, given that there's that discretion?
It's difficult to give a definitive answer. Like I said, that there have been also parties who've been using this to delay the process.
Right.
To generally say that you can use this as a ground to get an extension would not be correct. But from the institutional point, we would, of course, be willing and to understand each situation on its own facts. And if there is a need to grant an extension, it would so be granted. But there have been requests for extensions to simply answer your question.
Right, okay. Thanks. There's a question that's come up in the Q&A box, which I thought would be interesting to get your perspective on, as you sit both as an arbitrator and a mediator. And the question is, how is the pandemic making a difference to the med-arb or arb-med-arb practices? Have you seen, we've spoken a bit about arbitration so far. How has the circumstances affected the mediation practice?
It has had a very positive effect on mediation, because mediation inherently, is probably one of the loosest forms of dispute resolution. It's very flexible as a process, and it's a very useful tool to deal with very uncertain circumstances. So, when you have questions of contracts being frustrated or going into force majeure, we have seen, mediation being used to sort of renegotiate those contracts and see how they will move forward. We've also seen some disputes that were going into arbitration instead, be sort of diverted into mediation and be effectively settled. So I think, given the sort of, to use a cliche, the unprecedented circumstances we are in, it certainly has been very encouraging for mediation. During the 50-day lockdown in Kuala Lumpur, I myself saw 2 disputes being mediated and settled during that period.
Actually, this is,
sorry.
Yeah. Just to add, I think this is one of the essential innovations, or something that the parties, are necessarily looking to explore, is to settle the matters. If there is a way that they can find to settle the matters before having to run through the entire trial, they are very open to it. And this has been the general sentiment that I have sensed around, that they are willing and they're trying, that if they can avoid, getting into a dispute at all, or if it's already initiated, then if they can find a way around it.
Thank you. So that's another consideration perhaps for parties who find themselves in a difficult situation, to consider if mediation or some kind of process, which is not necessarily arbitration, could also lead to a resolution. Moving on to the next question. Angeline, this one is for you. We were discussing a bit about, and we picked up on this a little bit here and there, about due process paranoia and parties, talking about the enforcement of awards and making sure that the award is enforceable, irrespective of the process that's followed. And you can see situations where even though parties right now are willing to go ahead with whatever process is being put in place, but if the award comes and they're not happy with the result, they can turn around and challenge it later on. And so how do parties and how do tribunals basically control for that risk to make sure that that situation is not something that causes problems later on?
Well, I mean, I think my starting point would always be what are the risks to challenge or to enforcement as far as you can identify? So the first question is risk to challenge would be, well, what is the applicable law at the seat? What will the courts at the seat, what approach will they take to proceeding on a remote hearing basis? The second, which is the enforcement question, is always a lot more difficult because you don't know exactly where assets are going to be, but you can sometimes make an educated guess. And the reason why I say that's really the starting point is because obviously different jurisdictions will take, I think, there's the possibility that different jurisdictions will take a different view to all of this. So, and that, I think, will influence to some extent, the approach which the tribunal will take. But I still come back to, I think, so what practical steps can you take? So there is a recommendation, as I said earlier, that you secure a party agreement. Now, party agreement doesn't necessarily extend to a waiver of a serious due process violation, of course, and that may depend on the applicable law, but there certainly would be challenges in that respect. But I think the real question is, so obviously get that if you can get it and record it. There is, I think, a concern about raising the necessity of getting consent, because ultimately the tribunal has the power to determine whether to proceed on a virtual basis or not. And then the question comes down to what is the real due process violation in a particular case? And certainly speaking from a matter of English law, the key question will be, have the parties had a reasonable opportunity to put their case? And that feeds back into the discussion we were having earlier about what is really the difference between a virtual hearing and a physical hearing. And I would suggest for many instances, the differences may feel a bit uncomfortable to us who are used to physical interaction, but in terms of substance, the differences may be not all that great, and an extension of the way in which we've been conducting ourselves to date. But you know, we will, and so what can the tribunal do, or what would you want your tribunal to do in those particular circumstances? Well, you'll have to, first of all, hear from the parties as to what their view is on virtual hearings, identify what the key issues are, and take a decision which is well reasoned. But I think one of the things that tribunals are going to really have to grapple with is, this is not necessarily a case where you can say, okay, well, let's err on the side of caution and adjourn for 3 months and see where we are in 3 months, because it seems to me that there's a very, very real possibility that in 3 months' time we'll be in a very similar position to where we are now. So this is not a decision which can be put off, and the best way of protecting your procedure in those circumstances is to give a reasoned procedural order which sets out, if you feel that you can proceed, the basis upon which you feel you can do so.
And I think that's such an important point as well, given that most of the disputes that at least we tend to see are international in nature. Even if specific countries come out of lockdown, there's really no clarity on when international travel or borders are generally going to be open. So actually, in situations where you have parties from different jurisdictions, you're not really going to see physical hearings happening perhaps for a while still. So the fact that even if you try and adjourn it, when do you adjourn it to? When do you have the certainty? So I think that's an important question. And just picking up on a few questions that I saw which came up in the Q&A box, I think what's important to understand is that although the online hearings may be happening, that doesn't really affect a lot of the other aspects of arbitration. It doesn't affect the place or the seat of arbitration. It doesn't affect what the set-aside procedure is. That you'd still have to apply to the courts of the seat if you wanted to set aside. It usually wouldn't affect the enforcement procedure as well. You'd have to still apply to the jurisdiction where you're trying to enforce. So those kind of questions, which are perhaps basics of the arbitral process, don't get affected because of the current circumstances to quite an extent. So the last question, and because we have a bit of time, I think I'm going to ask all of you to gaze a little bit into a crystal ball, perhaps a very hazy crystal ball at this point, because we don't really know what's going to happen in the future. But how do you think what's going on right now is going to affect international disputes? So perhaps I could ask you to start, Shwetha.
I think I'm quite optimistic about what it will do to international arbitration, and I genuinely believe that I think the time has come for arbitration to revolutionize itself, to really reach its own optimum potential of what it's really capable of. So I think one big change that we would see in the future is the kind of disputes will really expand. Maybe hopefully see more institutional arbitration than ad hoc, because the structure allows you to operate and still have things done in more cost-effective manner and in timely fashion. So I think that's going to be one change, where parties will look to put in their own contracts more institutional arbitration clauses rather than going by litigation or ad hoc arbitration. Second change that I would assume be more and more virtual hearings. I think rather than in person, like you said, the situation is not going to get normal anytime soon. And it would not be a stretch to say that maybe till the end of the year we would still be confined to our countries, and where there are international arbitration, it's difficult to bring parties together in one country. So we will definitely see more and more virtual hearings. And that would become maybe the new norm even after the pandemic is over. I think it's a matter of getting used to it. Sometimes the reluctance is because we are not comfortable with a medium rather than whether or not that medium is effective. And I think technology has got a lot to do with more of not being comfortable than being effective or not. And I think once we start to use it more, which like I said earlier, we've been now compelled to use it, parties would of course get more comfortable, and this they will realize is a major boon because of the significant cost savings that they're going to have. So I think it's a positive future for arbitration. It's going to really shape it very differently, probably to the way it is intended to be, and not just theoretically talk about arbitration to be more flexible, more adaptable to its own way, but to really see its own potential in true form.
Thanks, Shwetha. That's very optimistic, I think, and hopeful. Thayat, are you as hopeful as well?
Yes, I am very hopeful as well. I have four predictions gazing through this pandemic. Firstly, I think as Shwetha mentioned, we're going to see a considerable reduction in in-person hearings. I think there will be an increase in documents-only proceedings as well. It may become the new normal, and parties may argue strenuously for a documents-only proceeding. In order to do that, they may front-load their case as much as possible, put the facts and the legal arguments up front and try to push for a documents-only proceeding. If that doesn't happen, then go for a virtual hearing on confined issues. I think that's very much on the horizon. It's probably happening already. Secondly, very interestingly, as we move to electronic communications, as everyone has said, has always already been, that's not something new. But as we move towards electronic communications, virtual hearings, documents-only proceedings, you can see that we're slowly getting untethered from any geographical location of the arbitration. there's no need to any longer think of a convenient geographical seat for the arbitration because you're never going to be in that city anyway. So, there will be this thought then of just looking for a jurisdiction which has, the most arbitration-friendly legislation and the most effective judiciary. And those jurisdictions will probably see an uptick in cases as a result of the pandemic because there is no reason to geographically go to a particular location anymore. Thirdly, what's interesting, and this thought crossed my mind as I was looking through the facilities provided by the Hong Kong International Arbitration Center for virtual hearings. So they provide 6 services: video conferencing, audio conferencing, electronic bundle services, electronic presentation of evidence, transcription services, and interpretation services. And if you look at these 6 services, and especially, speaking virtually out of Bangalore, what comes to mind? These are all things that can effectively go BPO. So you may see a lot of arbitration centers outsourcing all of this to another center to work on more effectively. And just to shout out to everyone in Bangalore, this may be a new growth sector for the BPO. And finally, I agree with Shwetha that this is going, in a way, it's going back to the roots of arbitration. All of this, if you look at it, electronic communication, virtual hearings, business process outsourcing, all of this is going to make arbitration a lot cheaper and a lot quicker. So we may actually be going back to the early days, of quick, effective commercial means of resolving a dispute. So I am very hopeful. In the famous words of Arundhati Roy, I agree that the pandemic is a portal. It certainly is, and I hope to set up and step out into a brave new world of arbitration. Thank you.
Thanks, Saya. Nihal, are you going to be slightly more cynical or are you going to be as optimistic as well?
I'm going to reserve judgment. I think what is important is when we come out of this situation is to actually document the experience that tribunal makers, decision makers, adjudicators have had with the virtual hearing process. Is to understand how it impacts decision making, understand how it impacts advocacy, and really at least give us more information on how we can do things going forward. One general and sort of stepping back from all this, one point I'd say is that I think travel is going to change a lot. It will probably be led by the clients that we work for and the business and commerce, because people will now be talking about carbon footprints and carbon emissions in more, I guess, in more robust terms, because we've all seen that you can have large meetings and conferences like this on video conference. And that will slowly, I think, trickle down to the arbitration and the legal community in terms of, whether you're having arbitration conferences where, hundreds of people are flying down to attend those or hearings. So I think there will be a way, change in the way we travel, which is only a good thing because it means more people can access discussions and conferences and debates.
Yeah, and I think that's such a good point as well. I think before this, none of us thought that you could have a situation where we're all forced to stay at home and we are not allowed to travel. And everyone thought that the needs of business and needs of commerce would overrule everything else. And I think this is something that's proven that assumption that we all made in our heads quite wrong. So it's making us question how things can be done rather than how things need to be done. So I think that's a really good point. Angeline, which side will you fall on? Are you going to be with Nihal or with Thaya and Shwetha?
I don't know whether I can go for a diplomatic third way, but I was going to have a go at making 4 predictions. I think firstly, we might see a more cohesive approach to remote platforms for the sharing of documents and filing of documents. And that's not just a COVID-19 driven initiative, but also I think will arise as a result of cybersecurity concerns and particularly sitting in Europe, data protection concerns and so forth. But COVID might hasten it. So that would be my first prediction. The second is one that I made earlier, I think we'll have less telephone hearings. I think the norm will be for case management conferences to take place like this rather than by the telephone, which was fairly frequent before. The third, I think, is that I mean, we're being fairly optimistic, but it is probably right to say that where we're conducting remote hearings, parties, tribunals may, by necessity or desire, want to make them shorter hearings than we would have previously had, because you might have witnesses or advocates in different jurisdictions across different time zones, which means that practically the tribunal can only sit for a shorter period of time each day. Also because it has a different type of exhaustion appearing from your home in front of a computer screen for many hours a day. So you probably have more breaks and so forth. And I say all of that because I think that will increase the pressure on arbitrators and parties to not necessarily move completely to document-only hearings, but to hive off issues which could be decided in advance on the documents. And this is something which those advocates who push towards a more efficient process have argued for a long time, that we should have more case management hearings where the tribunal is more active in terms of identifying issues which could be resolved in a different way. So my prediction would be that this COVID-19 will incentivise that. That's the third one. The fourth one, and this is maybe where I come down on both sides, is that I think, you know, there is a great deal of uncertainty now as to how long we will be in current circumstances where we cannot travel, or if we do travel, it will be with a 14-day quarantine attached to either end of that travel, which will make it practically extremely difficult. And we don't know how long that's going to go on for, and it could go on for 2 years or could go on for longer, who knows. And so in those circumstances, I think we will be proceeding with virtual hearings, because otherwise, you know, we don't have a justice system, and I'm not convinced that some of the due process issues are ones that cannot be identified. But once that's over, and one assumes that eventually this will be over, I'm not sure that we will continue completely with virtual hearings, because I still think that many people will be more comfortable for a long hearing having it where everybody is physically in the same place. So I think there will be, for very significant cases with very lengthy hearings and lots of witnesses, that we may see at that point a move back to physical hearings. That was my final prediction.
Thanks, Angeline. So I think it's been quite an interesting discussion today. And just to distill a couple of points that we heard is a lot has changed, but maybe tangibly not so much. I mean, we're doing things differently, but in effect, the arbitral process by itself remains pretty much the same in terms of the practices around it, in terms of what tensions the tribunal has to deal with. And the same applies to due process concerns. And when you actually distill it to what is affected by this, it's not very much. Question mark on how we're actually going to see these things play out in the future, if and when we ever return to what we considered normal once upon a time. But it seems like this will definitely help in bringing down costs. And some of our panelists think this is what arbitration is all about: fast, effective, cheap dispute resolution. So maybe that's what we're coming down to. And there are a few questions, and I think I mentioned this in the early part of the session as well, about cybersecurity and data protection. And the second session is going to deal with just that. So I guess all that remains is for me to thank all our panelists for taking out time on a Sunday to join us for a very insightful discussion. And thanks to the organizers for organizing this. And we've seen some great participation, some great questions from the attendees as well. So thank you all. Aman and Vignesh, is there anything that you guys would like to add at this stage?
Thank you so much, Shreya. There's not much that I would have to add at this point. You've largely covered most of what we had to discuss. I would just quickly go over the issues that we've managed to cover, which seem to be quite wide and good in my opinion. So we've largely ended on an optimistic note about the future of ODR and the accessibility of arbitration to a lot of people regarding this, and about how COVID has changed this whole process. We've discussed also quite a bit of procedural nuances coming from e-filings to examinations to discussing the merits of a document-only arbitration and so on. And we've also examined the response of various courts and other institutions to how this COVID-19 situation has panned out and how they've responded to it. So I think that is also an excellent point that we've looked at. And we've also generally talked about issues in enforcement and but despite all these challenges, we've generally concluded, like you said, about how the arbitral process has largely remained intact and due process concerns are quite effectively addressed by how we've managed to shift online. So I would once again, in the same vein, thank all the panelists for taking out their valuable time and being here, despite the differences in the time zones. I'm sure Shreya, Nihal, and Angeline had to wake up quite early in the morning to be able to make it to the webinar. So thank you so much for all that. And thank you so much to the attendees for turning out in such large numbers. We're extremely overwhelmed by the amount of interest that you've shown. We hope we were able to answer most of your questions. If not, we will continue to discuss. We want this to be a place where continuous discussions can happen around this and hopefully lead to better constructive solutions. So having said that, I think we can conclude the session unless anyone has any other points to add or anything else to say.
I think perhaps one other innovation of this is that we're ending it early, which never happens in arbitration conferences in person. So I think maybe that's one thing that might also continue in the future. But hopefully everyone else attends the second session as well. And good luck to the speakers for the second session.
Thank you very much.
Thank you, everyone.
Thank you.
Thanks.
Thanks, Shreya.